Welcome to The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide the information and resources that will help you decide whether you need to contact a lawyer or want to contact a lawyer. Perhaps will help you to determine that you actually can handle some issues yourself. If you do need professional counsel, you'll be better prepared, and hopefully so will the professional you select. Our goal, of course, is to help you achieve the best possible results while saving time and money. The Bazar and Associates law firm in East Providence continue to help us with the various issues that we tackle, and we want to, again, welcome and thank Attorney David Bazar. So today, product liability. Defective or dangerous products account for thousands of injuries every year in the U.S., and the legal rules that are responsible for the defective products and the dangerous products and who is responsible, it's kind of murky. Interestingly, there's no federal product liability law, but there are responsibilities that are governed by the state. So that'll be interesting as we talk about who is at fault and why. So we need some clarification here, David. So there are so many stories in the news, headlining. They're global stories, and they're out of this world in terms of the settlements. Give us a little tutorial about, we've talked about personal injury, and product liability is one of those things, but it's different.
It is different. Product liability is based on an injury that's caused by a defective product. And through the development of the law, there are a lot of different ways of going about a product liability case, a lot of different legal theories that you can use. You can use a breach of contract claim, for example, because you bought a product that was supposed to do a certain thing or function, and it doesn't do that, so they breached the contract to give you a product that was reasonably safe and designed to do the work that it was going to do. And under those contract theories, there's breach of warranty. The product actually has an explicit warranty that is breached, or it could be a breach of an implied warranty of merchantability, for example, that the product was sold to you to do a certain job and doesn't do the job, it can't do the job. So those are the contract theories. There's the straight negligence theories that you have, that they were negligent in making a product, either in the design of the product or the manufacture of the product, and the safety of the product in the design part of that would fall into that theory. And then it's just a product liability case based on the defective product itself. It's sort of a strict liability type of thing, but that a product is sold that's unreasonably defective and dangerous, and it's put into the stream of commerce. So the manufacturer who put it into the stream of commerce is responsible for any injuries that occur. The distributor who sells the product in the stream of commerce is responsible, and the retailer who sold it to the end-using consumer could be responsible.
That's quite an overview, and there's such a drill down to do on that.
Right.
One thing I wanted to ask you as a basic bottom line, I understand in reading some of this material that when it comes to product liability, the way that the injured or the victim sets up responsibility, he has less of an issue in terms of how he claims that there's been a defect, whether it's design and manufacture. You'll go through all that. But is it true that product liability is an easier hit than some of the other personal injury cases, that there's less that you have to prove? Is that really true?
Well, that's sort of touching very broadly on the idea of strict liability.
Okay.
So that once you can prove the product was defective, you've overcome a lot of the other issues that you may need to prove in a straight negligence case. So is it easier? No, not really, because the difference is in most straight negligent cases, and for that we'll use the rear end automobile accident, other than the doctors and the treating physicians and maybe other medical experts the defense might hire, you don't need an expert to establish the negligence. If you're hit from behind, it's under the law, presume that the person who didn't control their vehicle is responsible for the accident.
Sure.
End of story, usually.
Right. That makes sense.
In a products liability case, you need an expert. You need an expert to prove that the product was defective. And that can be very expensive and very difficult to do. But like you said, once you get there, a lot of it does flow a little bit easier.
So apparently, as you were starting to address, would generally ask who's responsible, but when it comes to product liability, there's a long line, as you were starting to allude to, from the design of the product, the manufacturer, every component that went into it, from the thing that somebody made into the thing, as they would say,
right,
and the packaging, and the wholesaler, and the distribution, and the retail. That goes on and on. It seems to me that if someone has a problem, they, as an individual suit, might be able to go after one, but they actually have multiple options to
right,
address or sue.
So,
true?
I guess, again, we're touching broadly, but on sort of like the global supply chain.
Yes.
And how things get made and components that go into different things that are made. So there could be a component within a finished product that is the defective part, but is everybody liable down the stream for that? I don't know a lot about this, but I'm sure there's a component that goes into a Takata airbag,
yes,
that goes into a car, that goes, sold to a person who buys the vehicle. And so if there's a defect that causes an injury to the consumer, the purchaser of the vehicle or an occupant of the vehicle, I would, as an attorney, suspect that I'm going to look at the company that sold me the car, the person or distributorship they bought the car from, or the manufacturer of the car, who in turn we're going to look at the supplier of the airbag and maybe the component that goes into the airbag and on down the stream, so that there could be a whole host of people, companies, that are responsible for what happened.
So the big issues in the news today, the Monsanto and Roundup, the weed killer, is one. Hip replacement, some cosmetics are in the news. We can go after and talk about some of these. But even casually speaking, the issue about the baby seat, the car seat, at what point is it the way the thing was made, or at some point is there an issue about the negligence or the irresponsibility or the inattentiveness or whatever of the user? Like the woman with the coffee cup at Dunkin' Donuts. Does the spiller have some responsibility?
Okay.
Does the way you tuck the baby in have some impact? How do you deal with that?
A number of things raised there. So let's just break them down a little bit one at a time. You raised a number of different types of cases. Many of those may end up being class action suits, and there's reasons for that. We can talk a little bit more about class action suits if we have time.
And Roundup is a good example of it.
Exactly. Roundup, hip replacement parts
Yes,
that don't work, mesh that doesn't work,
yes,
all of those types of things. Product liability cases, yes, but usually in the form of a class action suit. The defense to a products liability case. You were very close mentioning a coffee case, but it was McDonald's, not Dunkin' Donuts.
Oh, that's right.
Just for the record, because we don't want anybody to get upset with us. All right?
Sorry, thank you.
That's okay. And there could be a defense to a products liability case based on a misuse of a product. For example, there's others, but we'll take them one at a time. So a misuse of a product, a good example of that might be a ladder that's designed to be used one way that the consumer uses in a different way. So let's just assume that it's designed, I'm making this up, to be propped up against something to hold it, and you're only supposed to go up to the third or second from the top step, but you go all the way up to the top step knowing you're not supposed to do that, and you're not using it in the fashion that it's supposed to be used in, and you get hurt. The misuse of that product could be a defense. A bandsaw, for example, where there's a safety guard on it, that you remove the safety guard and you misuse the way you're using it. You're supposed to only cut certain material and you cut other materials and you get injured. misuse of the product can be a defense.
What about an unavoidably unsafe product? You buy an electric knife and you're cut, but if it's too dull, that's an issue too, never mind how it's used.
The way it's made is inherently designed to do the job it's supposed to do, which means that it is dangerous if you use it incorrectly, especially. So the type of product it is and how you're supposed to use it, there's not a product liability case for someone who cuts themselves with a knife or an electric knife if they misuse it. That's the defense. There's also, in Rhode Island, a comparative negligence defense. And this came from a case that was heard in the Supreme Court based on a football helmet, and a high school player was injured using the football helmet. The design of the helmet, the allegation was, and I think may have been proved out in the trial, was such that it didn't, the way it wore on a player's head could cause a neck injury, whereas it could have been designed not to cause that neck injury, using it as it's supposed to be used. Even using it as it was supposed to be used, it could cause the neck injury, so the jury found that it was a defective product. The issue then became, was the player trained negligently how to use it by hitting with the head instead of the shoulder, which in people who play football will know
point.
You tackle with your shoulder, not supposed to lead with your head, and it's a penalty nowadays, maybe not then. But in any event, that was a comparative negligence allegation on part of the defense that, well, he didn't use it correctly. And the court said, well, we can let the jury weigh in on comparative negligence. And yes, maybe he was comparatively negligent, so as we talked about how comparative negligence works, whatever his percent of negligence, he doesn't get paid for. The company only pays for their percent of negligence, so the award is reduced by his negligence, if there is any. And so that is a defense to a products liability case as well.
In this state, but to your point, does that mean also, though, if that same situation took place in another state, might the nature of that case might look a little different?
As you said, products liability cases are state to state.
State, not federal.
Right, and the rules of negligence and products liability and all of those things go state to state. So one state might allow a set-off for comparative negligence, other states might not, just as some states in a straight negligence case might say comparative negligence over 50 or 51% is a complete bar for the plaintiff to be able to recover, whereas in other states you can still recover.
And if you were defending the helmet manufacturer, I understand that if you can somehow prove that the plaintiff altered it or didn't quite use the product the way he was supposed to, maybe he didn't like the way the chin strap worked, or I can't imagine what the specifics are, but it would be hard for a defendant to prove that unless you had a snapshot or a way of seeing how he might have altered it, but that's considered to be a defense too. So if someone changed the knife blade in the knife or changed something in the band, some of those might be easy to prove. Others might be very difficult to prove.
So I've been involved in a lot of cases with that issue, and did somebody along the way alter the product from the way it was originally designed to some unsafe status? So what happens in Rhode Island, we had a lot of manufacturing, and there were a lot of injuries due to manufacturing equipment. And so we would oftentimes, you have a workers' compensation case, we've talked about this, and the third-party case, as you like to say, I think you call them dual cases or something. But in any event, we have the third-party case. And in this particular instance, the third-party case might be a products liability case. Was the machine designed defectively? And so oftentimes you'd have to go in and check, did the company owner change it? Did they take off a safety guard? Did they change how the machine was used? I think I had a case once where the machine was originally designed to be powered by water. And of course, after the 1900s and later on when electricity came to being, they changed it so it was powered by electric. But did that change the nature of what caused the injury in this particular machine? And so we had to hire experts to look at it and say, no, the safety guards were never removed. It only changed the motor and the mechanism that might have turned the belts in the machine. So the general design defect that existed when it was a water-powered machine still existed, for example.
It certainly shows the wrinkles within
Lots of wrinkles.
a situation.
Yep.
I had also read along the way, I guess it wouldn't really matter, but if you did not purchase the product, but you were a victim or victimized by the product, it stands to reason that you wouldn't necessarily go after a retailer. You might not even know who the retailer is, but you still might have a suit if the product itself wasn't made correctly. Maybe you can't go after the retailer, but someone's going to come to a lawyer and say, well, there are enough people in this chain, go after one of them because that product shouldn't have done it, even though my aunt gave me a birthday gift.
So really we're talking about a semester in law school on this. But so there was a case that decided that you did not have to have privity of contract.
Explain.
So in this particular case, you're really testing me here. But in this particular case, it may have been an automobile that was defective, and the husband bought the automobile, but the wife was injured in the accident or whatever was caused by the defect in the automobile. And the wife didn't buy the car, so she not the one who entered into the contract to buy the car, but
good example.
she
Okay.
was a reasonably foreseeable victim of the defect of the car. So the court said that no, we don't have to prove that privity of contract anymore. We just have to know that it's reasonably foreseeable by the manufacturer that this person is somebody who could have gotten injured in the accident. And so she is absolutely able to pursue a case for a product liability for the defect in the car.
So I want for us to talk about some of the bigger cases, but the one question I would have to you, if someone comes to you with what they think is a defective product or a dangerous product, you certainly can do a little research to find out if it's happened to one other person in this state, this country, or millions. There are individual lawsuits, and then there are things like the class action suit, which is the segue I want to address with the Roundup weed killer lawsuit that goes on. It's a global fight. It's not just on this turf, and apparently there are 11,000 pending cases, those being, I guess, the individual cases, not counting what's become a class action lawsuit. So that's a very big deal, and I guess the awards initially given at $289 million. You've talked about punitive damages and the compensatory damages, and now they're being fought. This is a very interesting case because it's going on and it continues to go on. How do you decide whether something is just to be handled as a single case versus let's just file it along with the class action, or there should be a class action?
So a single case example might be where there are automobiles made, for example, and they come off the assembly line, and most of them have no defects whatsoever. But one particular car that sold to your client is defective, and as a result of the defect, there's an accident. And it's a serious, significant injury, and as a result, it's worth the lawyer, like a medical malpractice cases we talked about.
Yes.
It's worth the lawyer's investment to hire the experts necessary to look at the vehicle to determine what the defect was and why it happened and why it shouldn't have happened, and to prove the case that you need to prove of a defective product. That's a one product injury to one person. These cases that become class action suits are where the product itself, no matter, there's no defect from the design or in the manufacturing process that caused the injury. It's the product itself. So it would be the design or the Roundup, maybe the chemical composition, or
which is what is at stake here.
Yeah, or there are the medical product cases where it's mesh, I think I've seen, and some other things where the product, even being used the way it's designed, is defective. And it's affected everybody who's had that product. So those are the types of cases that become class action suits. Tobacco back in the day. Many different types of products you've seen over the years where there have been suits, and these are the kinds of cases you'll see on late night TV, where these law firms that like to specialize in class action lawsuits will say, have you been the victim of asbestos, or have you worked with asbestos? You may not even have to file a lawsuit because there have been so many lawsuits filed over the course of time that a trust fund was set up because the company went out of business.
Yes, the mesothelioma support group automatically gives you some stipend to help you live, never mind the other things that happen attending that. Yes.
So those are the types of cases that would fall into the class action suit, as opposed to the one client who was injured by the one product that may have been a result of a manufacturing defect. I've talked about it before. I had the case where the woman, this is how far back this case goes, went to Almax and bought a bottle of an apple drink where the bottle itself was manufactured in a defective fashion. So when she picked it up and lifted it to put it into her carriage, the bottle just disintegrated. The glass shards fell and cut her leg, severing a nerve, maybe a vein, whatever else, causing, you know, some significant injury. And so that case was as a result of the manufacturer of that specific bottle, whereas other bottles may have been fine.
Sounds right. So honestly, I don't know how long every personal injury case or product liability case takes, but class action suits, as we know, go on ad nauseum. I could be buried 400 years before they settle some of them because they just linger. If you have a product liability case that seems reasonable that happened to this one individual, wouldn't it be a reasonable thing on a lawyer's part to say, let's settle this because this is one thing that happened to you? It's not that this might not be part of a larger issue, but would you tend to advise someone to tend to this one issue at hand versus delay, defer all of this?
So if a client has a significant injury and it's as a result of a defective product, and you have an attorney who's willing to invest the time and money into that, yes, an individual case on that kind of basis can be very effective in getting a recovery for that person. Many times what happens with some of these product liabilities is it's not a catastrophic injury. There's an injury, and it can be a fairly significant injury, but it's for judicial economy and for each client's own costs sometimes more effective to handle it as part of a class. But if it's a significant injury, you don't have to be part of a class.
One man, farmer, I believe, $289 million verdict. That was the initial with the glyphosate, the chemical that's the basis of this product called Roundup. That was Bayer's, that's Monsanto's. When there's something that goes wrong and they say that there's some negligence or there's a defective product, I can see that there would be some settlement, but obviously there was an issue taken with it. Now there's a judge who's saying, I think we're going to revisit this, and took back all but maybe $39 million. That's still a lot for one case. This isn't the class action, obviously. This is the one case.
It's sort of like the pilot case that they will use sometimes.
So this still isn't over, even though the initial award was $289. Then it's been rescinded to, or repealed, or whatever, 39. And now there's going to be still another case, I guess, to combat what is now been reduced as punitive damages. Is this pretty typical that this would go on and on? I don't know if this man has seen $1 yet.
Yeah, no, it's very typical, especially in that type of case.
So with that situation or that scenario being described, there's 11,000 more in the queue, never mind the class action suit. Do you imagine that this is going to go on for decades?
Yes.
Yes, that was a quick answer.
Well, didn't take the tobacco cases. The first ones went on forever until finally they started one after another and everything fell into place.
So we may not have a lot of time to cover what is the cosmetics industry, but apparently now that is an issue too. What goes into the cosmetics that's being made, whether it's lipstick or hair dye or foundation or serums or sunscreens. The FDC, Federal Drug and Cosmetic Act, another situation that's not federally controlled. How do we end up addressing things that you can't possibly know that went into the product because it's not listed on the ingredients list of being potential warning? So what recourse do you have if there is no warning? Is that just a marketing or promotional issue that you'd have a product liability suit for?
Well, but is there an injury?
Well, they're saying down the line someone ends up with some cancer.
Okay.
Not non-Hodgkin's lymphoma like glyphosate.
Okay. So, a couple of things. We did start out by talking about products liability being state to state.
Yes.
However, there are a lot of federal agencies that oversee a lot of different things, like the Consumer Product Safety Commission. And so even though the personal injury case is state to state, there's a lot of federal oversight to what products can include in them, what safety things they have to pass, the Consumer Product Safety Commission and the FDC, as you said, and with food, the FDA, I believe.
FDA.
Yeah, so, you wake up in the morning and you can think about how many agencies there are that control a lot of what's going on in protecting us from some of these things. So it's not just the individual lawsuit that protects you. But as far as the cosmetic industry and those types of suits, again, as an individual lawyer to take a case, it would have to involve a case that is either a significant injury, or it would have to be a class action suit if it's not a significant injury, but it involves an important issue that a lot of people would have been affected by.
How about this when it pertains to product claims? So, for example, try this snake oil. This is guaranteed to remove every wrinkle that you and I will ever have in our lives. They don't quite state it that with such hyperbole, but those are the claims. Are those potentially product liability issues? Because clearly there aren't a lot of products that can actually get rid of those wrinkles, unfortunately.
It's not what I would define as a product liability case, meaning that there's a defective product that caused an injury to somebody that they would be suing for that injury. It's a
warranty?
Or
not?
Yes, it is, but it's also a misrepresentation. It's a consumer fraud. It falls under a lot of other issues where companies can be taken to task either through class action lawsuits or by the government itself, where they want to shut something down, where they're saying you can't claim that's not accurate.
So in the issues of the hip replacement materials, even now the Roundup situation, in some cases the manufacturers are saying we shouldn't be held accountable for this because we did ask, for example, in one case it's the EPA, another one it's the FDC. We asked for approval, they told us we didn't need it, and now we're being sued. That sounds like a sticky wicket, David.
Well, there's a couple of things. The Food and Drug Administration, right, regulates drugs, but sometimes drugs get passed that don't do what they're supposed to do.
Boy, it sounds like a very complicated issue, and it will continue. We thank you for tuning into The Law Matters, and stay tuned because the law matters to you.